Mr. President of the International Association of Constitutional Law, Mr. Moss, distinguished guests, dear colleagues and friends, chers amis, chers collègues, bienvenue en Israël, amigos, bienvenidos también los de Sudamérica. I am very pleased to open the second session of the roundtable dealing with the comparative aspects of the unconstitutional constitutional amendment. This session has two panels, which means it's very long, and we'll have a break after the first one, after the speakers, and the discussion will have a short break, and then come back to the second time. To all our speakers, may I remind you that we have a time limit. I think that Martin Scheinen showed us what a good ruler he was on that. I hope that I can follow his steps. What I would like to say is that the unconstitutional constitutional amendment is not only a theoretical question. Several countries have already dealt with the limits, whether formal, substantive or material. And we're about to learn in this afternoon from the experience in different countries as to, first of all, the definition of such an amendment. Who is to define? Who has the power, the authority, the competence for the judicial review of such an amendment? Or, like we just heard, who is the guardian of the Constitution? Or who is the speaker for the substantive part of the Constitution? And of course, what is the reason? What is the cause? What may be the cause for such a judicial review? Meaning, what are the implicit or explicit, formal, procedural, substantive limits of the constitutional amendment? The first speaker of this afternoon on the comparative aspects is Professor Aharon Barak, former president of the Supreme Court of Israel. Professor Barak is one of the few jurists that not only in Israel, but also around the world, needs almost no introduction and no presentation. Just say the name. But anyway, I will say just a few words. A professor of law, dean of the law faculty of the Hebrew University of Jerusalem, the Attorney General of the State of Israel, originally appointed Justice of the Supreme Court in 1978. Justice Barak served as the Supreme Court President from 1995 until 2006. He was awarded the Israel Prize in Jurisprudence. And I think I can say that Professor Barak has influenced and enriched the legal system of Israel in almost every field of law as no one ever did before. It is an honor and a pleasure to welcome Professor Barak.
Shalom, thank you very much. My presentation will be divided in two. The first part, some reactions to what was said in the morning, an entry into the special question of what's going on in Israel on those issues. As I see it, the main problem of the unconstitutional constitutional amendment comes up when there is no eternity clause in the Constitution. If there is an eternity clause in the Constitution, and if the interpretation of the Constitution means that the eternity clause sticks, that's not just a declaration. If there is an eternity clause in the Constitution, then basically the main question is a question of interpretation. It's a question of interpretation of the eternity clause. What is the scope of the eternity clause? How much does the eternity clause cover? And if there is a provision that the court cannot exercise judicial review about things concerning the eternity clause, then it's the question of the eternity clause if this constitutional amendment is covered by this eternity clause. And so, for example, for me, the Turkish situation, in which there's a lot of literature, both in Turkey and about Turkey, in a way seems simple, because Turkey has an eternity clause. And the basic question, and when one reads the translation of the Turkish cases, is that I view them basically as questions of interpretation of the eternity clause. You may have a narrow interpretation, you may be a wide interpretation, you may disagree with the interpretation, that's fine. But you are in the realm of the interpretation, and therefore the question that the idea of an unconstitutional amendment doesn't make sense is in a way right, because there is because the way to deal with it is an interpretive way, and also you agree that an interpretive way is fine. You may disagree about this, the theory of interpretation, as we have disagreed in the past. That's right, but that's another disagreement. It's not this disagreement. So the main question comes up, what happens in a legal system like ours that has no eternity clause? And the question is it possible as an interpretive tool, and I'm coming back to interpretation, is it possible as an interpretive tool to imply that the Constitution includes also an implied eternity clause? It's a question of interpretation of the Constitution. And this interpretation, if it operates, the outcome of it will be, yes, there are provisions of the Constitution that a constitutional amendment that fulfills all the procedural aspects may still be unconstitutional because it violates the implied eternity provision. So the question now comes, how can a court or how can anyone think about an implied or implicit, in the morning it was called, how can one come to the conclusion that there is such a thing as an implied constitutional, an implied provision about eternity? Well, there are two ways to do it, and I think the Indians have done both. So I'm sure that our friend that will talk about the Indian situation will. One way to do it is a very technical interpretive move, namely to interpret the word amendment. To interpret the word amendment. You say, this Constitution allows it to be amended. Okay, what is amendment? Amendment means, and here comes a move that you may agree with it or you may disagree with it, but here comes a move that said amendments means that the whole remains as is. That it's not an amendment if you create basically a new constitution. You cannot, by an amendment process, do something which is totally new. You may disagree with this interpretation, but you cannot say that the idea of an unconstitutional constitutional amendment is something which comes from the moon. It's there. It's an interpretation of the word amendment. And in India, in fact, the first judgment, I think, that took it seriously, there are several before it, several of the judges took this route. They said, look, the Constitution says constitutional amendment. What does amendment mean? Amendment means that you correct what is existence, but you don't replace the existence text with a new text. This is one way. I myself am not a great admirer of it because there are constitutional ways to restrict its application. But there is another way, and again, an interpretive way, which says that when you interpret the express text of the Constitution, you can imply from the express text of the Constitution a limitation on the amendment process. Now, you may say again that you think that this interpretation is wrong, and you may say that the theory is wrong. All this accepted. But I think many, many constitutional courts are using this technique in some areas. I'm not saying in this area. But take, for example, the idea of separation of powers. The idea of separation of powers usually there is no section in the Constitution talking about separation of powers. There's no text, the express text in the Constitution talking about the rule of law. Well, there may be constitutions that there are, but not in every constitution. Even in the German constitution, it applies only to the Länder, not to the federal state. On the independence of the judiciary. There are sections dealing with the independence of the individual judge, but the independence of the institution, in many constitutions, there are no provisions. And there are many cases in different countries under different systems that said that the idea of the rule of law is a constitutional concept. And the idea of separation of power is a constitutional concept. And the idea of independence of the judiciary is, and when I'm saying a constitutional concept, I'm not meaning something above that is floating above the Constitution. It's part of the Constitution. In one of my judgments, I said it's written between the lines of the Constitution in an notice ink, in an ink that you have to work on in order to understand it. But it's written there. There's a beautiful book which I recommend to every one of you, written by Larry Tribe from Harvard, The Invisible Constitution. The Invisible Constitution. So even an American, because for them this, what I'm saying now is terrible, but even blasphemy, yeah. Even in America, a scholar like Larry Tribe says there are things which are so basic. There are things which are so basic that are part of the Constitution. Now, this, of course, all this case law deals with a statute vis-a-vis the Constitution. And the decision was that the statute is unconstitutional because it violates the Constitution. Here we are dealing with one step further, because we are dealing with the constitutionality of a statute, but we are dealing with the constitutionality of an amendment. But I think the idea that the text includes in itself not only what is expressed, but also what is implied, is a sound interpretive idea. And now the question is what is the scope of this idea? And one can come to the conclusion, as the Indian Supreme Court has come, that the scope of this idea is that you cannot have a constitutional amendment which alters the basic structure of the Constitution. That's it. So I must say I don't see any major jurisprudential or constitutional problem, a major political problem. The Turks could do it because the army supports the Constitutional Court. Yeah, I agree. But on the theoretical level, I don't see any major obstacle for a legal system. I'm not talking now who will say so. That's the next question. For a legal system to come and to say, in addition to the, if there is a constitution, then and there is no eternity clause, we imply it by an act of interpretation. Of course, then even more difficult question will come up. What happens if there is an eternity clause which deals with matters A, B, C? Can you imply an eternity clause with matters D, E, F? Another question, a much tougher constitutional question. But again, it's an interpretive question. So you may have two norms and they seem to be in contradiction, etc. We haven't come to this question till, but I don't see the very, very, in other words, I don't see something absolutely impossible, let's say in the German situation where you have an eternity clause 79, to come and to say this is not, those are not the only eternity clauses. There are some other eternity clauses. But you need a theory behind it. You need an idea what are the basic principles, etc., etc., and someone should have worked out. Then the question comes up, who is the one who makes this kind of decisions? Carl Schmitt thought that it will be the president. All right. Under the Weimar Republic, there was no judicial review. All right. But we have now judicial review. So it seems to me quite natural to say that the organ that makes these kinds of decision when the question of the interrelationship in a statute and a constitution comes up, the same organ will make these questions when the question of the constitutionality of the constitutional amendment comes up. In other words, it seems to me that in our post-World War II way of thinking about constitutionalism, we do see the courts, inter alia, they're not the only ones, of course, but we do see the courts as the guardians of the Constitution. And if the Constitution impliedly says that there is an implied eternity clause, that then as guardians of the Constitution, they should have also the power of judicial review of constitutionality of the amendment. I disagree with you, Claude, that it's the same thing as if a subsidiary legislation vis-a-vis a statute is statute vis-a-vis the Constitution. It's more, from the legal point of view, from the legal thinking point of view, it's the same thing, but from the political, etc. point of view, of course, it's totally different. But if already a legal system has decided that there is judicial review of constitutionality of statute, and if they decided that they can interpret the Constitution to include an implied eternity clause, then the third move to say, okay, it will be the court that will apply it, doesn't seem to me something that is shocking the conscience of the English-speaking people, as was mentioned in one of the judgments. Okay. Now the question, of course, will come up. What if we assume, as I do assume, that the legal system may provide an implied eternity clause, if you don't want to call it an eternity clause, if you want to limit the eternity clauses only to express, call it some other name. I'm not talking about questions of terminology. But a clause that says that some things cannot be amended. As the Indians say, the basic structure of the Constitution cannot be amended. Then, of course, comes the last question is are we stuck with this Constitution forever? And here, again, Carl Schmitt comes in, regrettably, I must say, especially for me here, you know. But he says, well, a new constitution. I do agree that if what you are doing is not an amendment to the existing constitution, but if you are talking about a new constitution, I think the new constitution is not subject to the eternity express or implied clauses in the old constitution. Then comes the question, which you talked and some others talked, are there any limitations on the third track that you mentioned? Are there any limitation on the activity of the constituent power in creating a new constitution? I must say that I myself haven't thought too much about it. My intuition is that if there are such limitations, they should be very, very limited. And what you have said about the idea, at least have the idea that the elections and the body that will write this new constitution should be someone that really represents all the public free vote, dignity of the voters, etc., makes a lot of sense to me, but I haven't thought too much about it. I leave this question about the new constitution open. And now, on this background, let me come to the situation in Israel. As in many other things, the situation in Israel is peculiar altogether. We don't have a text, Justice Benish has said so, we don't have a text which is called the Constitution. But we do have 11 basic laws, Grundgesetz. I think it was taken from the German Grundgesetz. So we have 11 Grundgesetz. For many, many years, the Israeli Supreme Court said that those 11 Grundgesetz are basically regular statutes. And they will be elevated on the constitutional level only at the end of the process. In 1995, a very important judgment within our internal legal system says, no, mistake. Those basic laws, it said on two basic laws, but later cases enlarged it, that those 11 basic laws are superstatutory norms. They are above the statute, above the regular statute. I don't want to go too deep into the question, how can a regular legislature create a text which is above it? Complicated matter. At least my theory was that the Israeli parliament, who has created those basic laws, has two hats. One hat is a regular legislature, and here he cannot do it. But he has also a hat of a constituent assembly. Because there was an election in 1948 for a constituent assembly. They decided to go piecemeal, so they have the power to do it, and this power was put into action, at least in the two basic laws on which the case discussed, which is our Bill of Rights. So under this decision of the court, we have now judicial review of legislative action. Though the text is not called constitution, though it is called a basic law. And if you ask an Israeli, does Israel have a constitution? Most of them will say no, because they mean by constitution a text that is called constitution, that is difficult to amend, etc., which we don't have. But if you call constitution a text, which, though it's difficult to amend, and it's not in one document, but in several documents, but it's from the normative point of view, it's above a regular statute, and there is a theory that supports it, because the body that made it is a constituent assembly, not a regular legislature, then for that purpose we have a constitution. And now comes the question, which is our discussion. Suppose a regular statute is passed. Okay, no, another point. We have 11 basic laws. The process of creating all the basic laws and to put them together into a document which is called the Constitution is not finished yet. It started in 1958 was the first basic law, and then every several years there is a new basic law. No decision was taken that the process is over. And in fact, there is in our parliament a committee, a special committee, which is named the Constitution inter alia, the Constitution Committee, the job of which is to create a new basic law and then to amalgamate, to take all these basic laws together, to call it a constitution, probably to bring to the people, to have a vote, etc. This process is not finished yet. So we are still in the process of constitution making. Some of it were already made, 11. Some of it are still missing, and we know exactly what is missing. Some 4 or 5 are missing. And the question now is, does the doctrine that I myself think is the proper doctrine of the unconstitutional constitutional amendment in the sense that I was talking, does it apply or not? This question came up before the Israeli Supreme Court at least twice. Once in a full obiter. In another one, it was the ratio decidendi of the minority, but the majority said, no, we have another. The majority adjudicated in another way. But at least I expressed my views in both cases. And I was I expressed my views in both cases. I was the presiding judge in the second case, the first case not. And I said the following. Now, what was the case? The case was a case in which a statute was enacted by our legislature that says that under some circumstances, students who want to pursue a religious studying career can do it, and they are exempt from the army. So we have in Israel 2 types of students, so to speak. There are students in universities, etc. After they finish the university, they go to the army before. And there are students, so-called, that can be life students, and they can, if they go and study in what's called a yeshiva, if they study in a religious school, and they are exempt from the army. And there are several conditions concerning it. And the question was, there's a whole history how it came up that they legislated it. I'll not go into it. And the question is this statute constitutional? Everyone in the court, everyone from the judges that participated there said that this statute affects a constitutional right. Under my view, and I was the majority view, I think we were 11, so 10 out of 11, we said it affects equality. And equality, though we don't have, as part of this process, we still don't have equality as a right, because our Bill of Rights is still partial. But we decided that equality comes from dignity. We have dignity as a regular constitutional right, not as an eternal constitutional right. But we have it as a regular constitutional right, as a right that can be limited. It's not an unlimited right. But we have it, and so we decided as an interpretive move that dignity includes equality. The question is very much disputed in this country. Many people think it's wrong, etc. But that's not the question that we are discussing here. Okay, so everyone agreed that equality is violated. And the question was basically the question, is this, not violated, affected? Is this effect on equality, is it proportional or not proportional? Because we have a general limitation clause, like the limitation clause, for example, in the Canadian Charter on Rights and Freedoms. A right can be affected if it's demonstrably justified in a free democratic society. Canada, with us, if it is a right that is for a proper purpose, fits the values of the State of Israel, and is proportional. So the question was proportionality. And I analyzed the case in proportionality terms, and I came to the conclusion that because it was the statute was a new statute, it said it was only for 5 years. It gave a timetable how the army should reorganize themselves. I said it's still constitutional. It is not yet unconstitutional. This is the remedy that was provided. Because I said if the situation will continue as it is now, it will become unconstitutional. A minority judge said, no, it's unconstitutional immediately. Why is it unconstitutional immediately? Because even if it fulfills the limitation clause, it's unconstitutional. If it fulfills the limitation clause, how can it be unconstitutional? Then he added, even if this statute will be made as a basic law, which means a constitutional realm, it will be unconstitutional. So I reacted, and the whole court agreed with my reaction. And here was my reaction. I said, look, I do agree that the idea of an unconstitutional constitutional amendment is here. See India, see some German cases, early cases, even before the Bundesverfassungsgericht started to work on it, and other literature. But I said, and that's my point, the application of this theory to Israel should be even more limited than, for example, under the basic structure doctrine. Why should it be more limited? Because we have not finalized our constitutional exercise. We are still moving. And if we are still moving, one should allow our Constituent Assembly, our parliament with the head of the Constituent Assembly, we should allow our Constituent Assembly to make moves further and back, to learn from its own mistakes and to move. So, for example, we had basic law government, which said that the government is elected by parliament. Then there was a new basic law government was created. The first one was abolished. And the second one said, no, we the people will elect the prime minister, but though the parliament can fire him. Didn't work. It was repealed, and a new enactment came up, which went back to the old system. One should allow such a thing in the process. So, for example, according to my view, if our parliament will decide that basic law dignity, the whole charter, we don't want it. I think in a regular system that has review, that has an implied eternity clause, it will not work. In India, they decided that an amendment, the change of one article about property is already unconstitutional. I'm saying that even if they take the whole Bill of Rights, I don't think it would be, I would very much against it politically, but I'm a judge, and that's not my politics. It's my understanding of the legal structure. I would say that it sticks, because we haven't finished the process. We are still in the movement. Let me give you another example. So we have this judgment of ours that said, in overruling previous judgments, that the basic laws are above a regular statute. Suppose there is a basic law that knocks out our judgment, and that says, for example, that there's no judicial review of legislation vis-a-vis our basic law. I would say that's fine. I would say it's fine. I hate it. I would resign, but I still think they can do it. Though it may be in other countries, take away judicial review will change the basic structure of the Constitution. However, there are things, and that's my last point. However, there are things that I think that even in our system cannot be done. They cannot change, our parliament as a Constituent Assembly cannot change the basic structure of the constitutional process which we are in the sense that they can, for example, they cannot, I do think, say that Israel ceases to be a democracy, or the values of Israel ceases to be the values of a democracy, or that the values of Israel ceases to be the values of a Jewish state, which are pillars of our existence here. This they cannot do. They cannot, for example, I would say that an appeal from the Supreme Court will go to the Parliament Constitutional Committee. Major violation, major effect on our constitutional structure. How do I reach it? Again, for me, it is an interpretive move. I have said, so let me just cite to you what I said in those judgments. I said, according to this view, a new basic law or an amendment to a basic law which negates the character of Israel as a Jewish or democratic state is unconstitutional. The people, the sovereign, did not empower our Knesset as a Constituent Assembly, not as a regular parliament, did not empower our Knesset to do that. The Knesset was authorized to act within the framework of the fundamental principles of the state as they are manifested in the Declaration of Independence. It has not been authorized to annul them. And in another judgment, I said that the Knesset was not authorized to violate the fundamental principles upon which all of our constitutional structure, including the basic laws themselves, are based, and the violation of which is substantial and severe. Those are words. Of course, you can draft it, you can think about it in a different way, but I do think that it will apply here. So I do think that if our parliament, for example, will come and make a major change in our understanding what we are, why we are here. And then I do think that this statute will be, that this amendment will be an unconstitutional amendment, and who can declare it? I think the court can, the Supreme Court, in Israel it's every court, but ultimately it will be the Supreme Court who can make this declaration. But it should be done very, very carefully in a very, very special cases. I said, for example, that the case before me, that the statute violated some aspect of equality, a very important one, who goes to the army. It's terrible. It's a terrible statute. I mean, we were, previous judgment of mine pushed Parliament. In the beginning, it was done, the exemption was done under an administrative act of the Minister of Defense. So we decided that the Minister of Defense doesn't have this administrative power, that it's an undelegable constitutional duty of Parliament to do it. So we knocked it out. So they were faced with the obligation to do something about it. They have done something about it. I hated it. I thought it's wrong what they've done, but that's not the question. I thought that this is not an example of an unconstitutional constitutional amendment within our framework. And this is where we stay now. What will happen in the interim, quote unquote, interim period in which our constitution or the basic law process is still going on? I don't know. Maybe tomorrow the Parliament will make, as a Constituent Assembly, will have a new basic law that they will say there's no judicial review. For my last 10 years, I fought against this idea daily. They may say that there is a new, the Supreme Court can do it, because the power of the Supreme Court to do it is based in a basic law, but a new constitutional court, this is a very fancy idea that is played here around, a new constitutional political court, of course, will do it. I was against it all my life, but I don't think it will be unconstitutional, regrettably. But the moment the process will end, and the basic law, and the process in the sense that we are creating a constitution by piecemeal will stop somehow, then, and we will enter into a new phase. Then within the new phase, we may have this doctrine in its full-fledged applicability, subject to what will be this new constitutional structure. Who knows what it will be? We may be pushed back to the pre-constitutional revolution, as they call it, situation, maybe. I don't know. Hopefully they will have an eternity clause. I agree with Sharon. We should have eternity clause. Maybe that the Jewish and democratic nature of the country should be as an eternity clause. I'm very much in favor of that. But now to talk about it is in a way premature. Regrettably, we had to deal with it in two of our cases in which the structure of the case law is quite clear, I think. And let's hope it will not be, the Supreme Court, I'm not there anymore, will not be obliged to imply it one way or the other. Thank you.
Thank you very much, Professor Barak. Now you all know why everything now seems so simple and so clear. The truth is that it's very difficult for me not to comment on what you've said. I think the idea that an unconstitutional constitutional amendment implies, first of all, the existence of a constitution is very clear, and Israel has no constitution. We have a constitutional process. But the idea of what are the basic structures or the fundamental values or the material core, meaning that we cannot change the basic structure of the process, but we can annul the basic law concerning human rights, meaning we can make disappear dignity, but the process of the constitutional process cannot be changed. This is something that I'm sure will cause a discussion in this floor. Let me now present you the second speaker of this afternoon. This is Professor Denis Baranger. He's Professor of Public Law at the Université Panthéon-Assas Paris 2. He has published widely on comparative constitutional law, legal history, and jurisprudence. Amongst his writings, we find constitutionalism and the role of parliaments, which is very nice in my point of view, parlementarisme des origines and le droit constitutionnel. Professor Baranger will speak about a new, old French problem. And with this intriguing subject, it's a pleasure for me to welcome you, Professor Baranger, to the podium, please.
Thanks very much. Let me put it this way. Constitutional substance is like mercury. It always escapes. Constitutional form is like crystal. It breaks easy. If one pays attention to the language they speak, constitution on constitutional rulings from constitutional courts are not self-contained. They themselves point to things either superior, of superior value that seem to stand above and beyond their enactments. Human rights, national sovereignty, republic, basic constitutional structure, you name it. Yet the legal apparatus of constitutional law seems ill-suited to express these superior concepts, values and structures. Entrenchment on constitutional review are there to protect the Constitution as such, and force political power to remain within its four corners. This generates a tension between the ends and the means of constitutional law. Legal limits to the amending power are a means to ease this tension, but it remains to be proved that they do not merely point to the contradiction rather than solve it. What I'd like to do today is focus on a rather narrow but topical instance of this difficulty, namely the way in which the French Constitutional Court has approached the issue of the judicial review of the amending power of the Constitution. 4 cases are usually discussed in this context in France. The first topical case is coeval to the major constitutional reform brought about by General de Gaulle in 1962, regarding the way in which the Président de la République, the head of state, was appointed. Since 1962, he is appointed by universal suffrage. The bill introducing that reform was voted by the people by way of a referendum of Article 11 of the French Constitution, not Article 89, which appeared to be the correct amending procedure in the Constitution. This came as a shock to many lawyers, even as we now know inside the Constitutional Council itself. The Council decided that it had no jurisdiction to appreciate whether the bill violated or not the Constitution. It based this interpretation on what it called, quote unquote, the spirit of the Constitution. It saw itself as a regulatory organ of the activity of the public bodies. Again, these are quotations. As a result, quote, the bills referred to in Article 61 of the Constitution, to which I will come back later, should only be held to be those voted by Parliament, as opposed to those which, quote, being adopted by the people by way of a referendum are a direct expression of national sovereignty. The next 2 relevant cases were decided in 1992 during the time when the hot issue of the ratification of the Maastricht Treaty was at the forefront of French politics. On 2 September 1992, the Constitutional Council was asked to review the Maastricht Treaty on the European Union. The claim was based on Article 54 rather than Article 61. So in the French Constitution of 58, there are 2 distinct procedural vehicles in order to trigger constitutional review by the Constitutional Council. Article 61 states that acts of Parliament may be referred to the Constitutional Council before their promulgation, before they are in force, to the end that the Council shall rule on their conformity with the Constitution. The purpose of Article 54 is different. If the Constitutional Council has held that an international treaty, an international instrument, contains a clause that's contrary to the Constitution, authorization to ratify the treaty may be given only after the amendment of the Constitution. Accordingly, on 2 September 1992, Maastricht II ruling, the Council ruled that there were no clauses in the Maastricht Treaty that came into conflict with the Constitution. The claimants had argued that the amending power had failed to amend certain key clauses in the Constitution, especially those protecting what they saw as the principle of national sovereignty. To sum up, what the Council responded was that, subject to certain procedural limits spelled out in Article 89 and to the protection of, quote, the republican form of government, the pouvoir constituant, constituent power, was sovereign. On the 23rd of September 1992, which is the Maastricht III ruling, a final attempt was made by several members of Parliament to have the Constitutional Council declare that the bill authorizing ratification of the treaty had been voted in breach of the Constitution. The Council maintained that it had no jurisdiction in such a case as, quote, with regard to the balance of powers as established by the Constitution, the bills referred to in Article 61 should only be those enacted in Parliament, while Article 61's procedure should not extend to those enactments that are, quote, voted by the French people by way of a referendum, as they are a direct expression of the national will, unquote. The fourth and last relevant case dates back to March 2003. Several members of the French Parliament referred to the Constitutional Council a bill regarding the decentralized organization of the Republic. The bill amended several clauses in the French Constitution. So the claimants based their claim on Article 61. And in a rather laconic decision, the Council maintained that it had no jurisdiction to decide the case. The three-paragraph decision, which beautifully exemplifies the Council's customary imperatoria brevitas, justifies this outcome only on arguments of jurisdiction. The cases I have just reviewed have contributed to the conclusion that in France, constitutional amendment bills are not subject to constitutional review. The Constitutional Council has repeatedly decided that it had no jurisdiction. It is open to commentators to state that the solution is now settled. Constitutional amendment bills are not justiciable in France, full stop. Others can express the views that the matter is less clear than that, although they had more arguments to their support before the 2003 ruling, obviously. Obviously, one of those arguments was the Maastricht II ruling, in which the Council stated that the amending power was sovereign subject, which created a lot of talk in France, sovereign subject to the provisions governing the periods in which the Constitution cannot be revised, on to compliance with the fifth paragraph of Article 89, to the effect that the Republican form of government shall not be the object of an amendment. In any case, many see the 2003 ruling on the decentralized organization of the Republic as a final statement as to the non-justiciability of the amending power in France. It came as good news to some who saw it as settling some perplexed questions of constitutional theory. For instance, a noted author has said that the ruling meant the end of a myth, namely that of supra-constitutionality. At closer glance, though, there is more to the matter than a blunt denial of jurisdiction. In the limited extent to which the Constitutional Council gives reasons for its decisions, generally, the language it chooses to use is not accidental. In the cases I have referred to, in the cases I have just reviewed, the Court's reasoning is based first on a very literal reading of the constitutional clauses defining its jurisdiction, and second, on a certain reading of the political structure of the French regime, on the way in which it allocates political power. The 1962 and 1992 rulings I have reviewed earlier refer to a specific kind of institutional pattern. The way in which this pattern is described is rather elusive, yet the pattern itself is quite clearly discernible. In 1962, the Council referred to the fact that there existed a spirit of the Constitution, which involved that the Council itself was merely a regulatory organ, I quote, dealing with the activity of the public authorities or public powers. In 1992, the Council made reference to, quote, the balance of powers established by the Constitution. This is obviously a structural argument that denotes something else than a norm, something outside the Constitution. A kind of mercury which is put in a new crystal, namely the Holy Grail of the Constitutional Court ruling. The idea of a direct expression of national sovereignty expressed in both the 1962 and 1992 rulings is yet another element that points in this direction. And in passing this way it accounts for the bluntness of the 2003 ruling. In 2003, the bill on the decentralized organization of the Republic had not been adopted by referendum, but by Parliament convened in Congress, the option for the court of invoking the authority of the sovereign people was just not available in that case. Hence, maybe a mere statement of non-possumus. Yet, the 2003 ruling, for all its abruptness, has its logic. It can be connected to several long-term trends in the history of French constitutional law. It identifies the nation with a representative assembly. What the parliament convened in Congress does, which is the amending power in one of the options to amend the constitution in the French constitution, what the parliament convened in Congress does is treated in terms of judicial review the same way as what the universal suffrage does. Basically, what it does, its acts are not justiciable. This is very much in the French representative tradition, what Claude Klein has called le discours français du pouvoir constituant. That's very much in the French representative tradition, at least the one established during the French Revolution. In the case of referendums, of amending referendums, the Conseil had identified the people that has adopted the Constitution in 1958, in the first place, the sovereign people of 1958, with the constitutional power named people within the Constitution, onto which the said Constitution grants the amending power. It shouldn't come as a shock to, at least to French lawyers. It's pretty much in our tradition of representative democracy. The representative is the people. The representative is the nation. The National Assembly was the nation in the revolution. This brings me to maybe to two final comments. In the case law I have reviewed, what the case law I have reviewed does is to allow a process of permanent derogation to the Constitution. Verfassungsdurchsprechung. It goes somewhere towards allowing a flux of constitutional amendments that has become very strong in the recent period. Many constitutional amendments, 19 since 1992, on many times by Congress, not by referendum. During the Third Republic, Raymond, the noted public lawyer Raymond Carré-de-Malberg, came to the conclusion that the Constitution on acts of Parliament were not sufficiently distinguished in French public law. Through the amending procedure of Article 8 of the Constitutional Act of February 1875, what was called in that text the National Assembly could revise the Constitution very freely. As there was no constitutional court, no constitutional council, no judicial review of the Constitution, it was open to Parliament to decide that its own acts were constitutional. That was at least the conclusion drawn by Carré-de-Malberg. Hence, the fact that the supremacy of the Constitution, in his view, was not sufficiently protected. So now we have a constitutional court, we have judicial review of ordinary legislation, but I think we have the same problem at a higher level in the relationship between the Constitution of 1958 and the Act of the Amending Powers. Are we not now in the same position as regard constitutional amendments, that there is no sufficient distinction between the pouvoir constituant originaire, the originary constitutive power, and the pouvoir constituant dérivé, or as some prefer to say, pouvoir de révision, revising power? I'm just asking the question. I don't know the answer to it. One last comment, if I may. The French court has chosen not to use the review of the potential power it would have had to review the amending power as a means to protect fundamental rights. It is not a vehicle to protect rights. What it has protected is certain principles like the national sovereignty of the people, like the separation of powers, like the spirit of the Constitution, whatever that spirit may be. But it has decided not to to protect fundamental rights that way. It has done so in other ways, but not through judicial review of the amending power. This choice has sometimes been justified by saying, for instance by Bruno Genevois, by saying that the growing body of international law on human rights was a better vehicle than the so-called legal limits to the amending power. This is an old crystal, it's broken. New ones should take their place. And also the new mechanism of Article 61.1 can also be seen as a more appropriate response to that issue, to that problem. Be it as it may, the conclusion to be drawn from the French experience seems to be that legal limit, at least in the French context, and because of the French political culture, seems to be that legal limits to the amending power have never been an adequate means to protect superior principles. Maybe this is due to the French democratic tradition as opposed to Republican tradition, maybe. Maybe this is due to a certain French legal conservatism, believe it or not. Yet, surprisingly, this may help France to move more rapidly to a next step of constitutionalism in which these superior values are protected in a different way. The Conseil constitutionnel has refused to enforce constitutional limits to the amending power, yet to do so, it has introduced concepts on values that are external to the text of the Constitution, to which this text only refers. They are now in its ruling. The Mercury has moved again to another location. It remains to be seen whether the rulings of the Constitutional Council protecting the Mercury of national sovereignty, for instance, are going to stand or if they will break as easily as crystal. Thanks very much.
Thank you, Professor Baranger. I think it's the first time this afternoon that we have heard the idea of non-justiciability of the amendment power. And I guess that later on we will hear that judicial review for this power is not a power to protect rights. It has been in some countries a power to protect rights, but later on they developed to a power to protect only the material core of the Constitution, not the rights within it. Our next speaker is Professor Iain Currie. Let me present you Professor Currie. He's the Secretary General of the International Association of Constitutional Law, and is a professor of law at the University of the Witwatersrand. I hope no.
It's possible to say.
No, Witwatersrand in Johannesburg. He teaches intellectual property law, media law, and privacy law. He's an author and co-author of books on the South African Bill of Rights, on constitutional and administrative law, and on the Promotion of Access to Information Act. We're very pleased to have Professor Currie with us in this roundtable to speak about the South African constitutional experience, and please.
Thanks, Suzie, and thanks, Claude, also for inviting me to talk at this star-studded occasion. I feel I'm going to say some very basic things by contrast. I'm also going to show you the text. This sounds reactionary almost, but I believe that constitutional law does involve paying attention to texts sometimes. I'm going to show you some of them, and you guys over there are going to struggle a bit. There's some space over here, but I want you to look at the words. As I always say to my students, you need to look at the words. Okay, South Africa has a rather interesting jurisprudence on this subject, judicial control of the form and substance of constitutional amendments. And it's a jurisprudence that covers, interestingly enough, not only the post-1994, the post-apartheid period, which is obviously a period which is characterized by a system of constitutional supremacy with strong judicial review. But there is also some instruction to be obtained from the pre-1994 period, the apartheid period, call it, with a very, very different constitutional system, a form of Westminster constitutionalism, governed by the principle of parliamentary sovereignty. Now, this is obviously not the occasion to deal with in anything other than the briefest way with the old regime and with a trio of decisions of the Appellate Division of the Supreme Court of South Africa. And I will just very briefly mention them. And in fact, I'm going to do no more than to say their names. There are three of them, and they remain decisions of considerable interest to those jurisdictions which are still under the influence of Westminster constitutionalism. This trio of decisions, confined as they were by the doctrine of parliamentary sovereignty, restricted themselves to testing the logic of judicial control over what they called manner and form, procedures in other words, They did not contemplate the possibility that a constitutional amendment duly passed by the procedures required by the Constitution might nevertheless be unconstitutional because it cannot be recognized as an amendment. This possibility, whether a change so radical and subversive of the fundamental principles of the Constitution may not be recognizable as a constitutional amendment at all, but is rather an abolition or a negation of the Constitution that cannot qualify for legal recognition, is in fact hinted at in that very interesting last decision in a dissenting judgment in that case. However interesting as these cases are, it is not until the constitutional revolution of 1994 that this idea gains something of a foothold in South African constitutional law. It's briefly entertained in South African constitutional law. Now, in what follows, I'm going to briefly recount the adventures of this idea of, call it of unconstitutional constitutional amendments, I guess, stemming from Indian jurisprudence, of a set of deep constitutional principles, also referred to as fundamental or basic structures of the Constitution that are unamendable, even by resort to the constitutionally prescribed procedures for constitutional amendment. And at the risk of spoiling the suspense, I'm going to give you right now a quick précis of that story in advance. It basically goes like this. Offered the opportunity of introducing a basic structures doctrine, the South African courts have declined the invitation, or at least they've shown very little interest in the invitation. The reasons are positivistic. They're grounded in the peculiarities of the constitutional text, and also in recent constitutional history, constitutional politics, call it. They are, I think, to use Professor Barak's phrase, a question of interpretation. Let me explain what I mean. Okay, I want to begin with, no, don't worry about that. Let's begin here with the Interim Constitution. Now, the Interim Constitution was the result of a lengthy and difficult process of negotiation between the representatives of the old regime, the apartheid state, and its opponents. Okay. It's a long and lengthy process beginning in the mid-1980s and commencing really in earnest in the 1990s with the convening of a all-party conference called the Conference for a Democratic South Africa, called CODESA. It ended 2 years later with the adoption of this document, the Interim Constitution. And interestingly, this constitution was adopted by the old parliament, the old whites-only parliament, on 22nd December 1993. Now, besides the remarkable symbolism of the old parliament voting rather meekly for its own demise, for its own end, to use the English idiom, it's rather like turkeys voting for Christmas. It's worth noting the importance of this fact from the point of view of legal continuity. The Interim Constitution, which came into force on 27 April 1994, and its successor brought about a legal revolution in South Africa, a legal revolution, reversing colonial and apartheid policies of racial fragmentation, undoubtedly revolutionary, epochal in their effect. Nevertheless, South Africa's political transition belongs to the class of transitions that Andrew Arato has described as negotiated revolutions. It also qualifies as a legal or rechtsstaatliche revolution, in the sense that far from representing a total break in legality, it was adopted in accordance, painstakingly in accordance with the procedures prescribed in the constitution of the old regime for constitutional amendment. And that was the point of showing you section 152 of the Union Constitution. This is the 1909 Constitution. And it's really in terms of this rule, this two-thirds majority rule of a unicameral procedure of parliament, basically, that the revolutionary interim constitution was passed. It used the old amendment rule. So, however radical and fundamental the changes brought about by this document were, they were brought about by a process of constitutional amendment. Now, in turn, this document, the Interim Constitution, provided a mechanism for its own amendment, and indeed, as its name suggests, it envisaged its own end, its own demise. It was to be replaced within 2 years of coming into effect by a permanent constitution. And the mechanism basically worked like this. The new parliament, constituted under this constitution, was to play a dual role of being the legislature and a constitutional assembly at the same time. The constitutional assembly, in other words, parliament sitting with a Constitutional Assembly hat on, as it were, had the task of adopting a final constitution for South Africa within 2 years of its sitting, with a 2/3 absolute majority. And it was bound to produce a constitution that conformed to a set of 34 constitutional principles that had been agreed on during the political negotiation process, the Cadessa process that I referred to earlier. Those were contained in the Constitution. Now, amendments of the interim Constitution itself were possible if passed at a joint sitting of 2 houses of Parliament with a 2/3 absolute majority. It's the old amendment rule. It's the 1909 Union Constitution Constitutional Amendment Rule. But there was a special rule, an extra rule, which applied to Chapter 5 of the Interim Constitution, which was the mechanism for negotiating a final text, a new text. This is Section 74, which shields the constitutional principles and the whole mechanism for certifying them from any amendment whatsoever. If you have a look at the words there, no amendment or repeal of this section or of the principles is permitted, nor can you amend in any way the requirement that the text must comply with the principles or that the Constitutional Court must certify the text is complying with the principles. It's an eternal clause, I guess, of a sort, but a very strange one because it applies only within a 2-year time limit. It's an eternal clause with a kind of sell-by date, I guess, built in. Yes, it's worth adding just a further note about legal continuity, and that's just to remember that the amendment rule for ordinary constitutional amendments is the same as it's always been. It's the Union Constitution's rule. Okay. Now the ordinary rule, not this rule. Obviously, there's nothing you can do with this. There's no changing it whatsoever. But the amendment rule of the interim Constitution itself, in other words, the rest of the text, was the subject of the decision of the Constitutional Court in the case of. I forgot to show you this. Amendment of the rest of the Constitution, 2/3 majority. Okay, that is amendable, subject to that special procedure. Now, in this decision, the Constitutional Court confronts a case challenging a constitutional provisions, changes to the interim Constitution, and it's really very technical stuff dealing with provincial powers. Okay. And as the court points out, most of the interim Constitution can be amended if you follow the procedures in Section 62. There's very little you can't change except what is specifically provided for in Section 74, the section I've just shown you. Nevertheless, the applicants are arguing, and they're saying that this change to provincial powers is a change so dreadful that it cries out to heaven as an injustice. It's really a bit of a stretch because it was nothing of the sort. But their argument basically goes something like this. Counsel for the applicant argued that the amendment was a matter involving an incredibly important principle. Developing this argument, they contend, just have a look at the language of it, amendments to the Constitution had to be made within the spirit of the Constitution. This violates the fundamental spirit. And the fundamental spirit, I guess, is a spirit which provides a rough equilibrium of provincial power. And this is what's being disturbed in this particular case. This submission leads Justice Ismail Mohammed into an interesting discussion. He says, first of all, that the reliance on spirit is misconceived. There is a procedure which is prescribed for amendments to the Constitution. You have to follow it. If that is properly done, the amendment is unassailable. It may nevertheless be possible, though, that a purported amendment to the Constitution, following the formal procedures prescribed by the Constitution, but radically and fundamentally restructuring and reorganizing it, may not qualify as an amendment at all. And where does he get this idea? Of course, you'll recognize the idea immediately. He gets it from India. He gets it from this line of cases, including the famous Kesavananda case. He refers to those decisions of the Indian Supreme Court and says, the Indian Supreme Court has held that supremacy of the Constitution itself, the rule of law, the principle of equality, the independence of the judiciary and judicial review are all basic features of the Indian Constitution which cannot be amended. They're not capable of amendment. If you're going to change them, you're doing something other than amending the Constitution. And it's an important list: rule of law, principle of equality, independence of the judiciary, etc. Okay. That said, this is all unnecessary. We don't have to pursue this because this is not in any way touching upon any of these things. There's nothing. The particular amendment in question is not touching upon anything that could be called a basic structure, any of this kind of deep structure and principle of the Constitution. Okay, so these are interesting, but they're also unnecessary remarks, indulging really the late Justice Mohammed's propensity for expatiation. They spawned, of course, a small academic cottage industry devoted to speculating on the existence of a doctrine of implied limitation to the power of constitutional amendments as a result. The thing is, interesting as it is, much of the speculation, along with Justice Mohammed's remarks, have been made redundant by the 96 Constitution, and I'll explain why. Okay, now, we need to move on to look at the 96 Constitution. Now, recall that the whole process of enacting a new constitution, a permanent constitution for South Africa, was the task of a constitutional assembly, which is essentially Parliament acting under different procedures. It was constrained, however, to produce a constitution in conformity with a political agreement, which was codified in the form of 32 constitutional principles. I've listed the first 4 of them there to give you an idea of their flavor. The principles are essentially a blueprint for a liberal democratic constitution. Constitutional supremacy, separation of powers, rule of law, independence of the judiciary, etc., etc. The compliance of the Constitutional Assembly's text with these principles had then to be certified by the Constitutional Court in a quite extraordinary exercise of the power of judicial review. Now, the interesting question is, what is the status of these principles, this blueprint, this kind of fundamental structure for a liberal democratic constitution, once that process has been completed? The interesting possibility that these may continue to bind future parliaments was expressly rejected by the Constitutional Court in its certification decision. According to the court, once the Constitution is finalized, it has been certified, that's the end of it. Compliance or non-compliance with the principles can never again be raised in any court of law, including the Constitutional Court. It closes the book on those principles once and for all, putting to an end that argument. Which means that it is not possible to object to amendments of the 96 Constitution on the grounds that the amended text no longer complies with the principles. Suppose that Parliament, following the procedures for amending the Constitution set out in Section 74, was to repeal the Bill of Rights. The upshot of this holding is that you can't argue that the amended Constitution no longer complies with CP2. I've listed it there, that there must be a Bill of Rights, in other words. Okay. And this is not necessarily a bad thing, as we've seen. Parliament should have the power to amend the Constitution in ways inconsistent with those principles. Constitutional development, the thinking seems to be, cannot forever be limited by the historically specific principles, the dead hand of the past. Okay. Principles also require the entrenchment of the entire Constitution, and I'll just skip ahead. That's the requirement of entrenchment of the Constitution, as a result of which there are 5 types of amendments specified in the Constitution as it currently stands. And basically just take a look at the first of them. They're reasonably interesting because they represent a departure from that old order amendment rule that I first spoke to you about. But the first of these is the most interesting. Section 1 amendments require almost unanimity, I suppose. 75% absolute majority is an extremely difficult majority to obtain. All the rest require 2/3. Okay, what then is this Section 1? It's the founding provisions. It basically sets out a set of the highest level principles on which the rest of the Constitution is to be organized. Okay. Comparatively speaking, the rest of the procedures are not particularly difficult. Okay, the rest of the Constitution has been amended 17 times since 1997. An 18th amendment is about to be passed. But an amendment of Section 1 has never been attempted. And there's never been an attempt to amend the Bill of Rights. Okay. Now, Section 1 changes things. I think the provisions of Section 1 make redundant the remarks of Mohammed in Premier of KwaZulu-Natal. Let me just remind you what those remarks are. Remember, he said that there could be a basic structures doctrine implicit in the Constitution. And just note what it says: the rule of law, principle of equality, independence of the judiciary, judicial review, basic features, etc. The thing is, all of those are really now in Section 1. And Section 1 expressly provides for their amendment, although admittedly by an extremely onerous process. Okay. Meaning, I think, and to cut a long story short, it makes redundant the basic structures argument briefly entertained in that judgment that I earlier showed you. I will take 2 minutes. There's one more possibility, and I just want to briefly advert to it before pausing. Okay. Besides basic structures, which I think have been rendered redundant by Section 1. Section 1 contains the basic structures and expressly provides for their amendment. Can be amended. Okay. It admittedly is going to be difficult to do. There's one more possibility, and that's that these provisions could have a type of radiating effect. Okay. It speaks, for example, of human rights and freedoms. You could argue along the lines of a kind of Ausstrahlungswirkung, the idea that these high-level principles radiate into the more specific provisions of the rest of the Constitution. Adult suffrage, for example. Sorry, is there the words? Democratic government, etc. All of that stuff radiates into the concrete principles of the rest of the Constitution, leading some people to argue, commentators have argued, that a change to the rest of the Constitution by ordinary procedures that affects, for example, the fundamental principle of human dignity or the fundamental principle of the protection of human rights and freedoms requires the 75% majority, providing a kind of super entrenchment of those provisions. That argument was briefly entertained in this fascinating case, but it was largely disavowed by the court. It largely blew cold on the issue, I think. So we have an interesting situation where a court has entertained the possibility, it has briefly considered the possibility of a basic structures doctrine, but has found no need for it. And the reasons for those, I think, are in the peculiarities of the text. Thank you.
Thank you very much, Professor Currie, for this most interesting presentation. Last but not least in this panel of this afternoon is Professor Judge Lech Garlicki. He's a judge of the European Court of Human Rights in Strasbourg since 2002. Professor Garlicki is a former judge of the Constitutional Court of Poland. He's a professor of constitutional law and an author of, I think, nearly 250 publications, but I haven't counted it. We're very much honored to welcome you here in Jerusalem, and he will address the subject of an international regulation. Judge Garlicki, please.
Thank you very much. First of all, let me say it's a real pleasure and honor to be here, not only among so distinguished members of the Constitutional Law Association, but also in this particular place with its history and everything which is connected to this history. Let me also say that my perspective is a little bit distorted on geographical, in geographical dimension, because of course I have an European perspective, and Europe is quite a story of success as far as integration, constitutionalism and other is concerned, but also as far as history is concerned, because my generation was an extremely fortunate generation. What we started as a group of miraculously survived persons, now we are members of a country which is a stable country, being a member of the European Union, NATO, etc. This really was almost impossible to invent as a prediction, and this makes us maybe a little bit too optimistic, believing that it always should be like that there's just a steady progress over the history of a generation. But it's not necessarily always like that. But let me start with 3 short observations of a general nature. The first is that the very idea of a state ruled by law is organized around the assumption that there must be certain hierarchy of norms that control the operation of the state. In other words, there must be some legal basis, and not only a legal basis, there always must be a higher norm constituting a standard of reference for any action of the state. Then secondly, that this hierarchy has a multi-level nature. In other words, not only there is always a norm of reference that allows us to assess a particular action or inaction as lawful or unlawful, but there is also another, higher norm of reference that allows us to assess whether the first norm is lawful or legitimate. And finally, the third observation is that the number of those levels increases in history of constitutionalism in the process of modernization or democratization of the state. Well, history, of course, it is historically, of course, it's well known that the first level emerged with the modern concept of parliamentary legislation, understood as a limitation of royal prerogative, and gradually it developed into concepts like Gesetzesvorbehalt or matière réservée à la loi, and gradually also there emerged a system of judicial guarantees in Europe, most taking the form of separate administrative courts. And then there was the second level. In Europe, 100 years later, it was the concept of a constitution, understood as the supreme law of the land, and understood as a higher norm of reference to control parliamentary legislation, and also gradually they emerged a system of judicial guarantees entrusted to a judge, a separate judge, ordinary judge. It doesn't matter. It's not necessary, of course, to describe those developments, but what we can say now very clearly in Europe, and not only in Europe, is that the constitutional level of norms of reference is playing a very prominent role. That for the whole operation of the state, and particular for the political process of government, this is one of the crucial institutions as we understood modern constitutionalism. Why? Well, of course, there is a combination of different features, but at least 4 elements should be mentioned here. Number one, that constitutional norms, or constitution in substantive meaning, has now a systemic or comprehensive nature. It means constitutions provide norms applicable to all areas. And what is more important, those particular norms are organized in a system that allows us to organize intellectually and axiologically those norms into certain type of coherent whole. Then, and of course, this allows us to interpret and to apply particular constitutional norms. Then the second feature is a relative precision of constitutional norms. More and more often, constitutional norms are drafted as legal norms, not as political declarations. And at the same time, and this is, of course, more important phenomenon, those written norms, even if they are usually quite general, nevertheless, they are constantly being developed and modified by a constitutional judge. And this all translates the modern constitution into a living instrument, but not only living instrument in the sense of an instrument that develops, but also an instrument that enhances its capacity to function as a genuine norm of reference, particularly in controlling parliamentary legislation. Of course, it's again not a written norm. Is this a visible or invisible but judge-made system of norms as developed in the, let's say, history of constitutional case law? Then the third feature is accessibility of constitutional review. There are procedures, and those procedures usually allow to different actors to start the proceedings or the process of judicial review. And finally, the fourth feature is effectiveness of constitutional review. They are binding effects of judicial decisions, finding unconstitutionality. Unconstitutionality usually nullifies unconstitutional norm as such, and or individual actions based upon such a norm. And those phenomena, as far as, let's say, control of legality and control of constitutionality is concerned, are of course well established and omnipresent in modern democracies. But now the next question, our question of today, arises. So what next? Is there also the third level, namely the level allowing to control the constitution or to control constitutional amendments? As it is well known, of course, this problem has been always present in the modern constitutional history, usually couched in the question how to protect constitution against illegitimate or unconstitutional amendments or modifications, and we'll probably hear from Ivan Smith about Article 112 of the Constitution of Norway. Then later we, of course, had all this development in the French constitutional laws, and after the since the end of the Second World War, we have more and more of this eternity or unamendable clauses in different constitutions. The problem, of course, also has been touched quite competently by the doctrine. Well, Carl Schmitt has already been mentioned here several times. Those who do not like mention Schmitt can also mention Mortati, who also was more or less in the same line as far as the understanding of the basic structure or basic identity of the Constitution. In brief, I think nowadays it's possible to detect in several countries the third level of norms of reference, namely supraconstitutional, or whatever name we use, supraconstitutional constitutional norms, whether written or judge-made, that may serve as basis for review of regular constitutional norms and in particular of future constitutional amendments. The question is, however, whether this new emerging level can be compared with these two other well-established levels I've mentioned before. Well, methodologically, yes, and I fully agree with both Aharon and Claude. Intellectually, this is more or less the same operation, comparing a lower norm and the higher norm and taking some conclusions whether they are compatible or not. But there are several buts or howevers. Geographically, those supraconstitutional norms or eternity clauses or judge-made eternity clauses are present only in few constitutions around the world. It's not a solution common or typical for all modern democracies. Substantively, those unamendable constitutional provisions, even if present in constitutional text or in constitutional doctrine or jurisprudence, are usually very sketchy, very general, and not always are able to meet requirements of legal precision. And if they are, they may be very short-lived. Remember the first version of the Portuguese Constitution of 1974, I believe, or 6. There was a long list of unamendable provisions. Where is this list today? Disappeared somewhere in the history of Portuguese constitutionalism. So, thirdly, procedurally, very few constitutional courts seems to be ready to enter into substantive review of constitutional norms or amendments. India is not a representative case for all countries in which such review is possible. And decisions of constitutional courts are rather focused on finding that no violation took place. There's no contradiction between the constitutional, supraconstitutional principles and a particular constitutional amendment. Therefore, if we take these four above-mentioned criteria, systemic or comprehensive nature of norms of reference, relative precision of those norms, procedural accessibility of the review, and the effectiveness of the review, it seems not fully obvious for me that all these characteristics apply to the reality of supraconstitutional constitutional norm or to the reality of process of reviewing their supraconstitutionality. And last but certainly not least, and also it has been already mentioned on several occasions, those norms on eternity clauses belongs to the text of the Constitution, and they may be amended and annihilated together with the whole Constitution, and then we are on the third track, and the question is what next? At the same time, this problem is not unimportant, even if Europe is now blossoming as far as rule of law and democracy is concerned, but nevertheless, they are old constitutions. Those old constitutions, if they have to be kept alive, they must undergo a constant process of a lift-up. The question is how far such a lift up can go. Take an example of Constitution of Belgium, which is not entirely similar, even in some main principal concepts to what Belgium started with 170 years ago. Then secondly, they are pre-revolutionary constitutions enjoying something like a life after life and representing some kind of constitutional patchwork. Hungary was mentioned, still living with the theoretically 1949 communist constitution. The same case was with Poland, at least until 1997, for 8 years of a transformation, but also to some extent Portugal. If we again compare the original constitution of Portugal and those concepts that were behind the original constitution of Portugal, quite, let's say, socialist oriented concepts, and the present text of the constitution of Portugal, it also seems not to be exactly the same constitution. So do we have a situation in which the very identity of this still existing but completely rewritten constitution has been changed due to the revolutionary process in East European countries, for example? Yes. Was it a crime? Probably no, but at least we have to see that, we have to realize that also such constitution exists. And finally, there is a phenomenon of something I would call legislative constitutional amendments, namely amendments to the constitution written in a very detailed manner, simply not to allow the constitutional court later to intervene. Also mentioned this morning, Article 60A of the German constitution is probably a clinical example. So, it is not completely impossible to realize that also in Europe, this problem of lack, let's say, of identity of constitution and constitutional developments of amendments, or other more, let's say, specific problems of destroying or invading the existing constitution, also those problems may be present. The concept of unconstitutional constitutional amendment based on these eternity clauses probably would not always help, because it's still not sufficiently developed, which means that we may have to go beyond the original constitution, its spirit, its supraconstitutional elements, its identity, and to refer to other external normative systems as ultimate norm of reference. And again, this is nothing new. The concept of natural law is well established throughout the history of political thought. Several ideas based on natural law, of course, had to re-emerge after the Second World War. Some of them were included into the constitutional texts, so now we do not know exactly whether human dignity is on one on the other side, plus there were some, as it was nicely said this morning, unwritten principles floating above the existing texts. But the problem with natural law is that even if it is quite attractive, again, it does not meet these four criteria unmentioned. It lacks a systemic comprehensive nature, because there are so many different and conflicting normative systems associated with natural law that it's very difficult to agree what exactly the scope of natural law is. It lacks precision, again, due to exactly the same reasons. It lacks procedural accessibility. The judges are not ready, nowhere in the world, to substitute natural law for written constitutional norms. And it also lacks effectiveness, because even if you find that something is in contrary with natural law, so what? Jus resistendi, but of course this is not a constitutional solution of the problem. So maybe we should go to another system of external norm of reference, and here international law is a kind of promising alternative, because of course international law has been in development since many centuries. Traditionally, however, it always remained completely separated from constitutional law, and it was more or less absent in constitutional disputes. What is new after the let's say, Second World War, or rather from the beginning of the 60s, is that there is certain merger of both perspectives, the perspective of constitutional law and the perspective of traditional international law, and even more supranational law as it emerged in Europe. So the question is, if we take into account this rapid development and the deep transformation of international law also, and in particular its newest offspring, the supranational law, the question is, can international supranational law be regarded as capable to function as a system of reference, how it mentioned these 4 criteria, and if so, could it be effective? Well, again, let's go back to this criteria, systemic nature. Yes, there is a system now of international supranational norms, and not only regarding human rights, in which the system is very developed, but also many other elements of institutional constitutional law. Parliament, judiciary, local government. So this is much broader than only human rights, even if it is very developed exactly in the human rights. Precision. Well, if we are ready to accept that constitutional norms are precise, the same applies to international norms, in particular international norms as developed in the case law of international supranational courts. And again, this is not necessary to be developed here, but this is now a completely new situation of a very detailed body of rules elaborated by those courts. Procedural accessibility, well, everyone can bring an application before the European Court of Human Rights. Effectiveness and enforceability, this is the problem. This is the problem because here the perspective is different. If we, let's say, have a constitutional norm, a domestic constitutional norm, which is problematic, and we have an international norm that says clearly something else, what then? There's no problem for international or European courts. Both the European Court of Justice and the European Court of Human Rights on several occasions decided, yes, we do have a power to declare that even a constitutional decision on the domestic level must still be in violation of the law we are enforcing. But it is not the perspective of the constitutional law, because the Supreme Constitutional Courts are usually not ready to give priority to international norms as far as their clash with constitutional norms are concerned. So this is probably one of the most important challenges for the, let's say, constitutionalism of the 21st century, namely, assuming that international law, at least supranational law, again, I'm talking about the European perspective, provides sufficient norm of reference to review the conformity of national constitutions with this supranational or international law. Could we somehow convince also the national judge that they should accept those international norms as norms of reference in process of reviewing the internationality, or whatever to say, of those domestic constitutional amendments? But even if not, it's always possible to say, going, let's say, back to the axiological perspective, even if a norm of a domestic constitutional norm that is in clear conflict with international supranational norms as developed by the international supranational courts, even if it is not possible to say that it is a norm that is null and void or unlawful, nevertheless, it is probably possible to say that this norm is illegitimate. And if it is illegitimate, it must have also some further connotations. To finish, is it only theoretical problem? I think no. I can envisage at least 3 areas in which national constitutions may soon begin to be in conflict with some international norms. The first is the area connected, generally speaking, to the fight with terrorism. Okay, capital punishment mentioned by Professor Preuss is probably rather theoretical example, but constitutional clauses exempting some types of terrorist crimes from other constitutional protection. I cannot imagine quite easily the question whether it would be legitimate under the international law. Second example, foreigners or aliens, deportation, asylum seekers, other procedure. Again, there is a very strong tendency in several European countries to limit it. Will it be acceptable under international supranational law? Another question mark. And finally, religion. And again, problems like constitutional amendment provided for cross in public places, constitutional amendment prohibiting wearing religious symbol of some kind, or constitutional provisions prohibiting construction of minarets. Again, one can very easily imagine a conflict. What then? There is no answer for today, but there should be an answer for tomorrow. Thank you.
Thank you very much, Judge Garlicki. Just let me wonder about the characteristics that you gave, whether these four characteristics that you said that any supra-constitutional value has to be according to, whether do they really have to be precise? Do we really want the basic structures, the fundamental values, the material core to be precise as the Constitution? And do we really care? Is it really important if the judge is not ready yet? Maybe the judge is not ready because it has never been called to judge upon this, let's say, unconstitutional amendment that is an unconventional weapon. Maybe we are lucky enough not to have to put our judges with this problem. So if it is not effective yet, maybe it's not a negative point, maybe it's a positive one. But just to comment on this very interesting conference of yours, let me just open the floor for some remarks. I have Julia and I have Michelle. Let me just write the names. And please be, you know, there will be no break coffee. Okay. Now that's Julia and Michelle, and then Susanna, and then, of course, Martin, and then Otto. Okay, this is this part, and, of course, Vicky. Okay, so you're ready to sleep here, I think. And Professor Reiner, yes. And Professor, which I don't... Toniato, yes, sì, perdona. Toniati. So I have 1, 2, 3, 4, 5, 6, 7, 8. I have one... Oh, Oliver, would you like to, Professor Dawn? So, okay, and Oliver Dawn. And that's it. All right, so it will be about 2 or 3 minutes, no more. And Julia, you are the first. But I'll be very tight with the phone. Now, 90, 89.
Merci, Madame la Présidente. Quelques remarques seulement sur les relations droit constitutionnel, droit international. En dépit de mon grand amour pour le droit international, je dois quand même signaler qu'il y a quelque chose qu'on doit distinguer. Tout d'abord, une distinction entre droit communautaire et droit de la Convention européenne des droits de l'homme. Pour le droit communautaire, c'est la primauté. Il n'y a pas question. Dans les domaines d'application du droit communautaire, il y a la primauté. Là, il n'y a pas de question. Après, sur la Convention européenne des droits de l'homme, le champ d'application est limité aux droits de l'homme, c'est-à-dire que ce ne sont pas tous les sujets qui posent des questions qu'on pourrait traiter sous l'angle de la Convention européenne des droits de l'homme et que ce serait justiciable. Et puis, je trouve que la plupart des cas où on parle des amendements constitutionnels qui sont contraires à la Constitution, le point de référence, c'est la Constitution, ce n'est pas le droit international. Alors, du point de vue systématique, je crois que le droit international peut aider en s'appuyant sur des clauses constitutionnelles qui exigent l'application du droit interne en conformité avec le droit international, mais ils ne peuvent pas donner la réponse sur toutes les questions puisque le point de départ, c'est la Constitution elle-même. Merci.
Merci.
Thank you. And I have a short comment and then a question that I want to ask Aharon Barak. The short comment, it reminds me that one can summarize the whole proceedings and the dilemma in what Habermas very elegantly puts in his book Between Fact and Norms, the English translation, as how do you validate legitimate law, which is it's a combination of Kant and Rousseau. And so you validate it by, first of all, in order for a law to be legitimate, everybody has to be in a position to say, I gave that law to myself. That's why it's binding on me. And at the same time, the law has to be universalizable, which is the idea that it should apply to all. And this problem that we're discussing today is somewhere, it's a tension between these two things. A wonderful ideal, but it doesn't work. So what I hear, and I will focus mainly, I think, Israel and South Africa, particular interesting examples because of their special constitutional situation. In terms of South Africa, a recent change that was difficult. In terms of Israel, that they don't have, as Aharon Barak said, a written constitution. So we're always hovering between the two. We want to, in part, the constituent power has to be justified democratically, and we shouldn't go above that. On the other hand, we have certain values, and those values are supposed to constrain democracy. They're very difficult to combine them happily at all times. And the question is how much of which and who decides and how we find out. Now, in the case of, I agree with Aharon Barak that it's a question of interpretation, but I wonder, particularly hearing him saying that it's an open process in Israel, why does the judge then have the power to be the spokesperson for the Constitution? I understand the argument once the Constitution is set, and then we need somebody to interpret the Constitution, and that person should be the judge. We don't have to automatically accept, but there are strong arguments in defense of that. But if the process is constantly open and for a revision, then it seems strange that the judge should take that position. So what justifies the judge in that particular position? One last comment. My last comment is about South Africa. I think the South African situation, you have the court interpreting the Constitution as valid or not. And there you have a special, I think the issue is that you have a special problem, which illustrates my thesis. It'll be 1 second. And that is, on the one hand, you want a democratic vindication by the African National Congress. On the other hand, the white minority wanted to have sort of fundamental rights, sort of a Kantian side of the Constitution to protect it against democratic revenge. Thank you.
I'll be very short. I have two questions for Aharon Barak. The first is a trivial question, and just please excuse my ignorance, but as you mentioned that the Knesset has this twofold nature of a constituent assembly as well as of a legislature, who decides when the Knesset is acting as a legislature and when the Knesset is actually acting as a constituent assembly? The second question has to do with another element you mentioned, which is that the Knesset, the basic laws enacted by the Knesset are limited by the core elements that you find in the Declaration of Independence, for example, Jewish and democratic. So my question is, like in Schmittian terms, the Constitution as the decision is the Declaration of Independence, or is what the Knesset was supposed to do and is in the process of doing? Thank you.
Professor Scheinin, please. I'm sure you'll be on time.
Yes. Well, I'd like to address the question posed by the last speaker at the end, Lech Garlicki, concerning international law as limit to constitutionality of constitutional amendments. And I have a different answer, which is basically that most written constitutions are incomplete, in that they are too focused on creating a legal order and failing to regulate the relationship between legal orders. That's why we usually have in constitutions clauses about how to incorporate international norms and what's the status of duly incorporated norms in relation to other norms within the legal system. But almost all constitutions should be seen to include an invisible provision saying the state and Parliament and the Constitutional Assembly are bound by international law. My statement is simply there is such an unwritten norm in all constitutions. Constitution-making power, constitutional amendment power, is bound by the international obligations of the state. This, of course, breaches the firewall between domestic law and international law, but I think it is a reality in today's world that we should accept that this kind of a norm exists within the material constitution. That's why I take issue with Otto Fersman as well, in the sense that interpreting the constitution is not interpreting the text. It's interpreting the norm. And every norm must be seen in its context. And the context of being bound by international law is very important in interpreting an individual clause in the constitution. Thank you.
Thank you. Professor Fersman,
please. Yes, yes, but it will not be very long, as I'm under your generous chairmanship. To Professor Barak. First, you started by saying there is no problem when there are eternity clauses. Well, why do you need eternity clauses, which rules out the possibility of just having different modes of revision according to the different importance of the legal ambit, as for instance in Switzerland, in Austria, in Spain. And precisely it was Austria without eternity clause who annulled. Second, and this is more of a problem, even though you may have an eternity clause or different modes of revision, that is some form of polymorphism, there is no logical link between the existence of polymorphism and the power to annul something which would be contrary to the higher constitutional norm. Where is your proof that this exists? I haven't seen it. I would be very, very curious to hear some more about it. Third, you said, and I found this very interesting, that there is a sort of basic structure in the Israeli constitution, if we can name it like this, democracy and Jewish character of the state, which would be considered non-amendable in basic laws. But what do you do if first the court is abolished, which you consider to be possible? There you would face an interesting deadlock. To Professor Garlicki, you raised, I think, a very interesting question, which is possible only if we have different modes of revision, but without an eternity clause. That is, when does partial revision amount to total revision? That is, there may be also a quantitative issue. And again, Austrian jurisprudence is very interesting on that. But that's just it. I was very much in sympathy with your criticism of natural law, of course, but then you elaborated your own natural law with your 4 criteria. And supranational jurisdictions up to now have no power to nullify norms of states. They may just declare them in violation. So this is totally different, a structure.
Thank you, Professor Fersman. Professor Jackson, please.
Thanks to all for a wonderful panel. My comment was provoked by Professor Garlicki's very interesting talk and his closing distinction between legality and legitimacy, which I think is actually an important developing mode for mediating between the growing international legal orders that exist in the world and domestic constitutional orders. And I wondered what he or others might think of a slightly different way of conceptualizing this that I've advanced in a recent book about moving constitutional courts towards a norm of engaging with international law or with the law of other foreign jurisdictions, in part to provide a kind of outside, if not check, an outside perspective on internal questions of interpretation. This is different, of course, from Professor Scheinen's approach about international law as trumping, but it is an approach, for example, in the South African Constitution of mandatory consideration of international and the Bill of Rights, and whether engagement might be a way of bridging this legitimacy, legality kind of space that I thought you so interestingly defined. I do think that international community is increasingly influential on the legitimate content of domestic constitutional norms. And indeed, that is one way of thinking about the recent crisis in Honduras. I don't have time to go into it in a comment, but one might think that the international community around the inter-American human rights regime has taken the position that certain strong constitutional protections for the single-term presidency are themselves unconstitutional. So something to think about. And just a little bit on Professor Rosenfeld's comments. So I'm not sure, being an American, Kant and Rousseau, I don't, well, we'll but the idea is, let me give a different vocabulary, of local authorship and of good principles. Maybe they don't have to be universal, but a tension between those two. And the idea of good principles, I'm going to come back to something I said this morning, has in part to do with the outward-facing functions of constitutions. You want other nations to have respect for you. So that's just a little riff on Michelle.
Thank you. Thank you very much, Mrs. Sacher.
Excuse me to be so slow. I broke my leg, and for that I'm not completely healed up. First of all, we speak sometimes of the constitutionalization, or in part constitutionalization of international law. And there is a tendency, vice versa, certain internationalization of constitutional law. I think that universally recognized values cannot be amended even on a parallel constitutional level. So we have, maybe in regionalized systems, and the Strasbourg Court speaks of an ordre public constitutionnel, or European, ordre constitutionnel européen, that there are limits, and quite independently from dualist or monist view. That's my first. Second one, can the interpretation of the Constitution and of internally clauses by constitutional judges be unconstitutional? That means we have a jurisprudence which relativizes Article 79, paragraph 3, our internally clause, saying that these principles protecting against amendment have their inherent system immanente limitations. We do not know what that is so exactly, but is there a limit also to constitutional interpretation? And maybe if there is a separate opinion, so one of these opinions, predominant or separate, must be unconstitutional. Well, and the third one, to my colleague from Paris too, souveraineté nationale indivisible, but you inserted title, and you have this problem with limitation de souveraineté et transfert de conditions essentielles de l'exercice de souveraineté. Inserting Chapter 8 of into the Constitution means allows European Union a transfer of sovereignty to European Union. Is this unconstitutional because incompatible avec article 3 de la Constitution, peut-être? Merci. Thank you.
Thank you. The second panel this afternoon has been at least as rich of suggestions as the one this morning. So I will limit myself to just one question. I forgot Roberto Tognati, University of Trento, and presently University of Haifa. For those who are convinced about the plausibility of limits to unconstitutional amendments, it seems to me necessary to frame this particular institute almost as an oxymoron. In other words, the revision of the Constitution is not so much an instrument to change the Constitution, but an institution to protect the Constitution as it is. In other words, an instrument for regulating the scope of revision of the Constitution. In other words, to keep the law above politics. Now, of course, the assumption, and Professor Smith this morning put a question, I think he didn't receive an answer. How do you decide what is unconstitutional and what is not? Now, of course, the assumption is that some revisions of the Constitution, some amendments, might be radically, or rather radically, contrary to the historical and political process that led to writing that particular constitution. Now, in particular, let us think of transition countries. Now, it seems to me very acceptable that after, let's say, a political struggle of liberation, or after coming out of apartheid in South Africa, those who write the new constitution try to establish some boundaries just to make sure that one doesn't go back. Of course, all this is very relative. It's very much rooted in the history of one country. What we're doing here is just we're trying to compare experiences of different countries. So I don't think really that perhaps we should let the theory of law, the theory of public law, overcome an analysis of comparative law based very much on the history of writing individual constitutions. Let us just think then of the fact that the Declaration of Independence declares Israel as a Jewish and democratic state. This is not general. It has to do with the very history, of the very roots of this country. Thank you.
Thank you.
Thank you very much. I'm British, and we don't have a written constitution. No, most of us aren't. And I'm very struck by an obvious theme in the papers this morning and this afternoon about the importance of the people as the source of the constitutional power, or a constituent assembly, pouvoir constituant, or whatever it is. And of course, we don't have such a thing. Now, I think what I'm going to say might link in quite well with what Vicky Jackson said a few minutes ago and what the previous speaker said. Because one of the points about a recital in the Constitution that we the people have done this, or the Constituent Assembly did that, is that it provides a constitutional narrative. And it reminds me, if you look at Genesis or John, in the beginning were the people. In the beginning was the Word, and it was good. And that serves a legitimating purpose to successive generations, especially once the excitement of we the people actually doing it, if we the people ever did. Now, that's one constitutional narrative, and I must say I don't think creationism is really the flavour of the month. Now, the British constitutional narrative, I don't think we agree on one, but one of them might be something along these lines. Unfortunately, we have to have a government. We don't like it, but we accept that it's necessary, and we've had one since at least 1066. But over the years, the people, in various ways, have forced upon the government a change of the terms on which we tolerate being governed. I heard someone once, a couple of weeks ago actually, talking about a tradition of patriotic acquiescence. And so I haven't got the time to go through the history, but there came a time when people said, well, we're not prepared to have the House of Lords. Unelected exercise much power, so its power was reduced. There came a time when the Scots were saying we want our own parliament. If we don't have our own parliament, we won't vote Labour. So Labour introduced a parliament for Scotland, and so one could go on. And this, of course, is an evolutionary narrative. And my thought is whether one wouldn't get insights into how constitutions are amended by accepting the fact that there is an evolutionary story there, and that the creationist in the beginning was the Word or were the people, maybe blocks off one's ability to think about these things. Thank you.
Thank you very much. Maybe I'm sorry it was too short. We'll hear the comments now of Professor Barak, and then Professor Garlicki, and then up to the last comment. And it will have to be short because we are already out of time, and meaning that you only give up your coffee or you give up your break. And I'm sorry, but sorry.
Well, I'll give some answers. Yes, we are an open process, as I mentioned, but this doesn't mean that it is a process which is not a normative process. It is a normative process. And so I see the process of our parliament at the Constituent Assembly, the continuing Constituent Assembly. If it's original or derivative, these are questions that are disputed here. And they operate within, as you said, Professor Oliver, within a narrative. So they are operating within a narrative. Where do I learn about this narrative? Well, I have different sources of learning about this narrative. The Declaration of Independence is one source. It's not a binding source. Our Supreme Court said that our Declaration of Independence is an interpretation, is a document that embodies rules of interpretation, how to understand everything else. So it's not the Constitution itself. And it's our history, and it's our traditions, etc. And basically, it's not different from the way we interpreted regular statutes and we interpreted regular provisions in the Constitution, and in the way that we'll be interpreting our new Constitution if we will have a new Constitution. Of course, there are others who think differently. I mean, I just was expressing my view on that. So I see in this respect, yes, there is a difference between a statute vis-à-vis the Constitution, and there is a difference between that and an amendment of the Constitution, the unconstitutional to the Constitution. I accept it's not the same thing politically, etc., etc. I'm sure that if the Israeli legislature would know what's going on here, we will have many problems, but luckily enough, he doesn't care about these kind of questions. But ultimately, I do think that even Parliament, with the head of the Constituent Assembly, is not free to do whatever it is. We have not authorized it. Our narrative has not authorized it. We, the people, have not authorized it. You can use different doctrines about it. Susanna, it's a good question now. How do you decide what we decided in our basic case on it, that those enactment by Parliament which have in them the chapeau, the name, basic law, and all are in this character, and none of and no others. And there is an open question. Every provision in the basic law says, I mean, there are many things open. We will solve them slowly, slowly. The fact that many questions came up doesn't mean that we don't have a solution. It means that we have a problematic solution, and slowly, slowly we'll solve it. And so what the case law now says, a super statutory norm is a norm which is embodied in a basic law. How do you know it's a basic law? It says it's a basic law. And all the 11 basic laws said basic law. They were drafted in a way that there's no time of enactment. Usually in our statute have enacted statute of 1985. They don't have 1985. It's eternal. It goes to the future, etc. Okay, so that's about it. About the Declaration of Independence, I said already. Now, I think one should make a distinction, at least in my mind, I make a distinction between two questions which I think that they are different. One question is, do we have this concept of the possibility of an unconstitutional, of an amendment which doesn't fit the amendment process in the Constitution, and therefore you call it an unconstitutional amendment? This is what we were discussing here. Another question is, do we have a procedure, a way to decide these questions? Are courts authorized to do it? Two different questions. I could live very easily with the idea that we have the doctrine of unconstitutional and constitutional amendment in the sense that we are discussing here, and that there is no judicial review on it, and there is no president who decides it, but it is thus a moral or a personal or a political obligation of every member of Parliament. For me, this question starts with, I'm a member of Parliament. I know, I would like to know how to vote. Should I vote for what seems to be under those rules as an unconstitutional constitutional amendment? And I'm a very normative guy, and I ask you, answer me the question. There's no court. There are countries, I mean, the Netherlands has no court for regular judicial review. So I'm sure that they will not have they will not exercise judicial review under this system. So, but again, there is this second question. Now, as far as this second question is concerned, there are subdivisions in it. Is there any provision in the Constitution that there is no judicial review, which may be? Secondly, and is this constitutional, which is connected with the first question. And secondly, even if there's nothing in the Constitution, is the structure of the court system such that there is a court that can do, and is authorized to do it in the Constitution? Now, our Supreme Court is authorized in the Constitution, in another basic law judiciary, says the Supreme Court, acting as a High Court of Justice, has the authority to decide if any act of any public authority is legal or illegal. So I see in this kind of text an authorization on the level of jurisdiction, not on the theoretical level we were discussing, but on the level of who made you, who give you the authority to do it? Well, you have given me the authority to do it. Then you ask, okay, so if so, what will happen if they'll annul the courts? No courts. No courts, I think, is so basic that our constituent assemblies, a derivative constituent assembly, cannot make in a basic law and cannot make in an amendment to a basic law. It's just out in, it's not in their cards. They just can't do it. It's like in South Africa, it violates those 32 principles. You just can't do it.
So the review power of your court, that would be absolutely sufficient.
Yeah, yeah. Okay. So, all right. So they can do it. Now, let's say they say, okay, the courts are there, etc., but your court cannot make this review. I express the view, but maybe after your remark, I'm mistaken. I express the view that they can do it. Holmes once said, I think for America, that if there would be no judicial review of legislation in America, it's fine, subject to the federal questions. On federal questions, you must have judicial review. On other questions, you may have it, you may not have it. And also, I think that it's not judicial review is not a necessity in this respect. And you may have a system, and there are many. France, until recently, had a very limited kind of judicial review. I think it's wrong. I think it's bad, etc. Now, your last point is that my answer that the amendment may knock out the court. So how do I? So what is my theory about an unconstitutional constitutional amendment? Well, then I have a theory without a court. But many theories are without courts, and I think the best theories are without courts. Okay, all right, all right.
It's not easy for me to say that. Please. Put me a very, very difficult decision.
All right. What I'm going to say, of course, or what I was going to say, is not that I suggest you to substitute international law for constitutional law. And I think the most typical scenario, as Julia mentioned, is that constitutional law is being applied in light or with the help of international or community law. But at the same time, from the practical point of view, I have an impression that from time to time we have constitutional amendments or constitutional provisions of a dubious content. We have a situation in which eternity clauses case law is unable or unwilling to solve the problem, so we must look for solutions somewhere else, and this international supranational law, as understood in Europe, might represent one of the possible avenues. Of course, they are distinct creatures, international law and constitutional law. But we have also to have in mind the enormous change of both constitutional law and international and supranational law. They are completely different now than they used to be 50 years or 100 years ago. That reference to international law cannot result in nullifying a law. Of course not, because had it been possible, then the third level would already exist in a clear manner. But is it really so? Let's imagine there is a case now pending before the Strasbourg court. I'm not sitting in the composition, so I can talk about it. Some abortion regulation in Ireland, constitutional provision. Now let's assume that our court would decide this is in violation of the convention. Of course, it would not nullify this constitutional amendment. But now, will the ordinary courts in Ireland be still able to apply those norms and to punish for abortion in such a situation? If we say yes, it would mean we are still back to the traditional approach. If we say no, then it would mean that practically the amendment would be nullified. So everything is in motion, and I think this is at least not an unpromising direction, direct reference to international supranational law in Europe.
Thank you very much. Thank you very much. Dr. Garlicki,
Je vais dire ça en français parce que c'est un tantinet philosophique. Mon collègue Arnold me posait une question sur le contrôle des conditions essentielles d'exercice de la souveraineté. Oui, le Conseil constitutionnel a dit ça à un moment à partir de 85. Je voudrais étendre cet usage. Je voudrais faire une remarque sur l'usage du vocabulaire essentialiste de la part des cours constitutionnelles dans le contexte notamment du contrôle des limites matérielles. Je crois comprendre dans la littérature italienne qu'on parle de contenu essentiel de la Constitution. Désormais, l'article 72 de la Constitution française parle des conditions essentielles d'exercice des libertés publiques. En Allemagne, on parle de la substance des droits fondamentaux. En France, depuis 2006, le Conseil constitutionnel parle de l'identité constitutionnelle de la France et on retrouve cette terminologie dans le droit communautaire, bien sûr. Pour le juriste normativiste, c'est assez désagréable parce que, et le juriste non essentialiste, comme le sont les juristes modernes, il n'y a pas d'essence du droit et il n'y a pas d'essence des concepts juridiques, que tout se réduit à de la production normative. Je pense quand même qu'il faut regarder les choses telles qu'elles sont et regarder ce que disent les cours constitutionnels, regarder le vocabulaire qu'elles emploient, et on verra que l'essentialisme n'est peut-être pas dans la philosophie, mais qu'il est dans le monde du droit, et qu'il est dans le discours, dans le langage des cours constitutionnels. Et ça, il me semble que ça jette une certaine lumière sur une discussion relative aux limites, je préfère dire limites juridiques ou limites légales que limites matérielles, parce qu'il y en a qui ne sont pas matérielles, il y en a qui sont formelles. Qu'il y ait ou non des limites légales dans le texte de la Constitution, il y a de la part des interprètes de la Constitution des raisonnements, disons, essentialistes, grosso modo, qui nous montrent que la Constitution renvoie à sa propre intériorité. Elle renvoie à sa propre essence. Les concepts constitutionnels, il faut en trouver l'essence. Et parfois, elle renvoie à une extériorité dont elle est une sorte de reflet. Les droits de l'homme, on manifeste son attachement aux droits de l'homme, on les déclare, on les reconnaît. Ça n'est foncièrement pas un processus d'interprétation normative. Ça n'est pas de l'extraction de la signification objective d'une manifestation de volonté. C'est un processus d'interprétation conceptuelle pure et simple. Et je pense que quand on parle de limites matérielles, en tout cas de limites légales à la Constitution, extrêmement souvent, et c'est ce que disait le juge Barak à propos du fait qu'au fond, il y a celles qui sont écrites dans la Constitution et puis il y a les autres, extrêmement souvent, le raisonnement essentialiste nous renvoie à cette idée que dans la réflexion constitutionnelle, y compris la production du droit par les juges constitutionnels, il y a un raisonnement non normatif, extra-normatif d'interprétation du sens des concepts. Merci.